Right.
ಅಲ್ಲ ಬನ್ನಿ ಸರ್, ಮೇಲ್ಗಡೆ ಪಕ್ಕ ಹೋಟ್ಲ್ ಪಕ್ಕದಲ್ಲೇ ಮೇಲ್ಗಡೆ ಹತ್ಕೊಂಡ್ ಬನ್ನಿ. ಹಾ ಹೌದು ಹೌದು.
Hello. Good morning. Yes. No. There is nothing of that sort. I have to go for my treatment only. After that, that's the thing. Otherwise, no. Yeah, that's all. Otherwise, no. I'll just go to my this one place for medical. My eye problem is that I have to clear it. For last 3-4 months, it is pending. That's all. Nothing. Nothing. That's all. Hello. No, definitely you should go because whatever help and other things are required. Unofficial or officially I can do, no problem. It is my personal file. Once it has given, I have to do. And I will be behind this, definitely. After coming, I will just join also. I don't mind. Because there should not be, I don't know. Just I have to go there and find out. And I may be there for about 15 days or. But I can even help in that regard after coming. No problem. And now you have to file it. Do it. Whatever you want, I can ask me. I will definitely. It is my file only. Even after giving to anybody, I don't have any this no, nothing of that sort. Things should be proper. That's all. Yeah, very bad, very bad. Because judge also he has not seen anything. Simply he was passing an order just to see how he has, within no time, even our judgments, our precedents, what we have filed, and nothing he has seen. He has not even mentioned so many things. And even this type of case, Supreme Court, this one, they have upheld certain things which he has not done. Even that acquisition itself is very much illegal based on Supreme Court precedents. And two very big decisions are there. And even Chandrasekhar, KDP advocate also telling it is your winning case like that. 2-3 times he told, he is my good friend only.
They just made big orders that is to make us shut.
Yeah, you have to go and you will be, it is a 110% winning case. Not 100. Yeah. Yeah. If anything is there, you can call me also. I will tell. Okay. I can give it, no. File whatever is there, no. It is only order and some other this one previous papers. What our Gowda has filed here. Rudra Gowda. Okay. Yeah. Uh,
The result, appeal fails and is hereby dismissed. Yes. Two weeks preemptory. 2 weeks preemptory. Permit counsel for the applicant that the needful has been done. The appeal be listed for order on admission.
Dinesh was appearing for appellant. Court notice has been
Is be issued to the appellant for his appearance before this court on which date? 6th of April 23. But you agree that's the most important thing. Earlier order means order dated 21st October 2019. Yes, correct. Mark the presence. This intra-court appeal has been filed against an order dated 21st October 2019, passed by learned single judge. in WP number 52010/2017, by which writ petition filed by the appellant has been disposed of. Paragraph. Learned senior counsel for the appellant will be submitted that the order passed by the order. Acha. All right, learned senior counsel for the appellant submitted that the order passed by the learned single judge was upheld by a division bench of this court by judgment dated 19/7/21, passed in WA number 3983/2019, and the aforesaid order has also been upheld by Honorable the Supreme Court as set aside. Paragraph. All right. Learned paragraph. Learned senior counsel for the appellant further pointed out that in the writ appeal, an observation was made that the interest of the private respondents shall be subject to the order which may be passed in specially petition by Honorable the Supreme Court. It is further submitted that it is also submitted that they filed an application seeking review of the order passed in WA 3983/2019, which was allowed by a division which was allowed by this court, and thereafter therefore this appeal has come up hearing. A paragraph. It is also submitted that which order has been upheld. Further submitted that the in view of it is fairly submitted that in view of order dated, where is the DA number? It's one asked in additional grounds, right? Where have you? Order dated. This is right. 20th February 23. Order dated 20th February 23. Passed by Honorable Supreme Court in civil appeal number SLP number SLPC number 8692/2020. The order passed by learned single judge deserves to be respected. The aforesaid submission has not been opposed by learned counsel for the respondents. We appreciate the fair stand taken by learned senior counsel for the appellant for the two of submissions made by learned senior counsel for the appellant, the order dated 21st October 2019 is maintained. In the result, appeal is disposed of. 19/7/21. 19/7.
Hello. Oh, yeah, okay. No, I'm attending the court. Quota number 2, I am having a case now. Virtual hearing, I am appearing now. I can, we can in the High Court or Ramchandra can come and I'll give the file to you.
We don't know what if there is no direction to issue. Give.
Hello.
You want to contest, right? So then don't let the appeal be listed, delete everything, let mark his submissions. However, where you have said no, submission is not opposed. However, the aforesaid submissions are opposed by Mr. Krishna, learned counsel for the BDA, in view of let the appeal be listed for orders on admission.
Upper for appellant, my lord. Upper for appellant. I'm sorry for the coming for VC, my lord. My lord, in this matter, my lord, we have paid the trial.
Clubbing, what clubbing? Which clubbing?
Copy has not been served, my lord. We have not received any.
Password.
We have not received any notice, my lord, in that matter.
IA for one of dispensation allowed 2 weeks peremptory. 2 weeks preliminary. Hearing. Yes. Who have filed? But who have filed an application? Married senior counsel. You are appearing for appellant. Heard on IA 1 of 23, taking into account the nature of controversy involved in the appeal, as well as and for the reasons assigned in the IA, same is allowed. Let the appeal be listed for final hearing on what date? Next
Hello.
week, 16th March 23.
Hello. Good morning.
Interim order granted on the earlier
No,
occasion.
I mean the core, this one only. Here, virtual here. Here only, computer. Just now I sent the this one photo. Court has already started. No, it is 11th matter is going.
Huh?
Just to send it now.
Undertakes to file objections to IA 3 of
Yeah, yeah.
2022
Yeah.
during the course of the day. When do you
Send the
want?
photo.
madam? Based on next week is
47.
Monday. Based on Monday.
It will reach today by 12:30.
Why earlier? IA 1 of 23 shall be considered in the month of June 26, June 23. That's March. June 23. We are much older. Kids.
Yes.
They shouldn't list it on 1st of June. You give a note to them. That order doesn't mean that 1st of June, right? June. Why? This warrant is granted 3 weeks time to comply with office object. 3 weeks. It has to be heard now. So when will you? Yes, Mr. Reddy.
Hello.
But you
Oh,
are
it is-
making submission.
So you can say already.
Will
sent the-
argue. But I mean, this is not the proper dress code to appear in the court, right?
Yeah,
It's
yeah,
not
it
a
will
park,
be-
even though it looks like that it is situated in a park. But this
No
is High
trouble.
Court, right? You should, if you want to appear, then follow the proper dress code. Not like round neck. This is not a college campus, right? Where you can walk in. All right, we will hear you.
Yeah,
Yes, to
it
appeal
will be
the
there.
committee, sir. He has engaged
You can
lawyers.
see the court.
You have engaged a counsel, right?
Mobile also you can see. Yeah. Okay.
Right? Not arrived. Let him arrive. Let him arrive. We will take it up and pass for round. In any case, on an office objection, it can't be heard like this. We will pass it over, madam. At the end of position hearing cases, let his counsel come. No, that's correct. But see, mister, we are bound by rules. Micus, tell him what are the rules. Party in person committee has to apply, seek approval. We cannot permit like this. What is this? I mean, see, he is standing. When you should, it's a direct insult to you, right? You should be here. You are standing. Client is saying he is unable to argue, and he is appearing itself like a patient treating himself, right? So what type of doctor you are? Go away. Stop practice, or at least withdraw from this case, right? You tell Mr. that counsel, tell him, tell the counsel. So, Mr. You listen. Listen. So just a minute, come here. So counsel doesn't want to do anything. You sit down. Why should you stand, Mr.? Sit down. Relax. Mr. Counsel, you relax. You don't want to do anything, right? So sit down. Sit down. Please relax. So see, Mr. If you want to argue your own case, please file an application before the party in person committee that I want to argue my case, because you are already represented by an advocate, right? He has filed wakalat. If you want to argue, then please file an application now before the party in person committee and tell them that why you want to argue the case. Then if the party in person committee, we will ask the party in person committee to examine your case, and they will pass an order today itself. Thereafter, you can be allowed to appear in person. But without permission of the committee, it can't be done. Got it? So you make an application to that committee, and we can take it up tomorrow. No, not to and fro. Hey, Mr. You do this formality today. We will hear your case tomorrow. Once the party in person committee grants you the permission to appear, thereafter you can address us tomorrow. We don't want to detain you here. We will hear the case tomorrow itself. Got it? He will help you. He is a government advocate. Why? No. You can't say. That's the problem. The prior this thing is, we can hear you provided you get the permission from party in person committee. This government advocate will help you. He will make you understand what is it about, what you are required to do, how to file an application. Go and file an application, appear before party in person committee. Will request party in person committee to grant you permission today itself. If it grants permission, then we will hear you tomorrow, right? So that is a precondition. Before we can hear you on case. First of all, she has to be heard, then we will hear you. Right? But you do that formality. We are bound by the rules. It can't be done. You are represented by not one, two advocates. The other advocate, he appears, doesn't say anything. When I pass an order, the other one will come, and when we are hearing some other case, he will interrupt us. Today we will teach him a lesson if he does so. We are warning you. No, but he is not saying anything. He will argue. All right. So then you sit down then. Sit down. Let him argue. So, yes, Mr. At the end of motion hearing cases, this has to be heard finally. Madam, we will not permit more than 25 minutes, right? It can't go on 1.5 hours, 3 hours. We don't have that much of time. Those old days are gone. If you can't finish your case in 20 minutes, the inference is that you don't have a case. There's nothing. There's nothing. 20 minutes we are giving you if you want. Otherwise, we will admit it and hear it leisurely when the turn comes. That's what we are putting you to notice. Mr. 15 minutes. Not beyond that. Whatever you have to say, there is nothing great about it. It's a custody of the child. Give us list of dates. No. Statement of objections filed. Then we'll fix a date. When will next week some date? Tell us a date. The moment we will tell the date, you will say, I am not there. Huh? Not 30, thereafter any day. Huh? 16. You don't want to file any rejoinder? Learned counsel for the petitioner prays for short accommodation, enable him to file the rejoinder if so advised. List for hearing on what date? 14th of 16th of March 23. You have to make. Huh?
So cancel.
Since the name of respondent number 5 was deleted by an order of the trial court dated 16/12/2015, comma, he has not been treated in the appeal in view of aforesaid office objection. What is it? Appeal is admitted for hearing, issue notice, record. IF dispensation. Dispense with. Huh? Oh, please appreciate in this writ petition, we are not monitoring the investigation, right? Habeas corpus means if somebody is in legal custody against his wishes. Where have you said that your wife or whosoever daughter is against, has been detained by such and such person against her wishes? Tell us. Oh, that person is not included in the petition. Whose custody? Commissioner of Police? No. Whose custody your daughter is? Huh? No. Mister, you will have to include that person, right? Supposing if somebody is having an affair, right? Extramarital affair and goes, so you will suspect and file a writ petition for habeas corpus, correct? You want us to decide whether it's maintainable or not? No, if your wife runs away, elopes with somebody, so you will file a habeas corpus. Why did she go at the first place? In whose illegal custody she is? Tell us. From perusal of the averments made in the petition, it is evident that the daughter of the petitioner is missing. Full stop. Her husband, namely, namely son-in-law of the petitioner, has also filed a complaint that his wife is missing. So there is no averment in the writ petition that the daughter of the petitioner has been detained by anyone against her wishes. So, therefore, in our considered opinion, the writ seeking the writ of habeas, the writ petition is not maintainable. Cannot be entertained. Cannot be entertained. Not maintained. It cannot be entertained. However, liberty is reserved to the petitioner to take recourse to such remedy as may be available to him in law. With the aforesaid liberty, petition is disposed of. Before that, you write can't be maintained. Learned additional government advocate has learned High Court government pleader has submitted that that on the basis of the complaint made by husband of the missing person, the investigation has already been initiated and is being carried on. Needless to state that the line below, needless to state that the same shall be carried to its logical conclusion. Seven days control. Appeal is admitted for hearing. It's of IA 1 of 23, 2 of 23, and 3 of 22. Next. Divorce. Appeal is admitted for hearing. What stays there? All right, appeal is admitted for hearing. Record. Record is there, Mr. Admitted for hearing. Admitted for hearing. Admitted for hearing. Admitted for hearing. Please. Records of family court. The requisition. Admitted for hearing. Ah, 5 years. 5 years you didn't do anything, right? It's that case.
Not this one, sir. ADB, sir. This point.
Ah.
15 orders, they have not done it.
Ah.
Final notification is not. Password. sir.
Password.
Let's go. Then, ma'am,
Next 24. Password. Appeal is admitted for hearing. Order granted on earlier occasion shall continue. Yes, madam.
thank you.
The records are in transit and not yet received to record.
When do you want?
Published.
100 additional. Huh?
Grants are- technically there is a grant order in-
Then you have to do it right now.
Okay. To establish grant order in accordance with law.
You are at always liberty. Who prevents?
Delay in the-
This intra-court appeal has been filed against an order dated 18th of November 2019, passed by learned single judge, by which a writ petition preferred by the respondent has been allowed. Paragraph, facts giving rise to filing of this appeal briefly stated are that Committee for Grant of Lands to Unauthorized Occupants of Bantwal Taluk passed a resolution on 13th of February 2004 to grant 0.57 acres of land in survey number. All details given in para 2 of the order of single judge. And so, Bantwal Taluk DK district in favor of the brother of the appellant, a brother of the respondent, paragraph. A brother of the respondent who expired on 5th of January 2012, paragraph. Thereafter, the appellant submitted a representation on 25th June 2012 requesting to issue a Saguwali chit in favor of his deceased brother. Full stop. The deputy commissioner by communication dated 9th of August 2012 rejected the request of the respondent. The petitioner, the respondent, there filed a petition direction in question of order dated 9/8/2012 passed by the deputy commissioner, as well as a direction to Tehsildar Bantwal to issue Sagovali chit in favor of the respondent. Learned single judge by an order dated by of November 2019 has allowed the appeal. Full stop. Hence, this appeal. Learned additional government advocate fairly submitted that in compliance of the order passed by the learned single judge, a Sagovali chit has been issued in favor of the brother of the respondent. In favor of the temple. It is pertinent. It is pertinent to mention a paragraph. Full stop. We have heard learned counsel for the parties at length from the facts. It is evident that the deceased had bequeathed the property, bequeathed the land in question in favor of a temple by a registered will. Full stop. The learned single judge therefore has rightly quashed the endorsement dated 9th of August 2012 subsequent to the direction issued by the learned single judge comma Sagovali chit has already been issued in favor of temple in question. Paragraph for the aforementioned reasons. At this point of time, we do not find any ground to interfere with the order passed by the learned single judge. It fits and here.
20th of March.
20th March, right? No, 2004, 20th March. Yes. Huh? What objection? Is delay?
Filing this appeal.
Appeal.
Yes.
You have filed the appeal. So what is the reason assigned for condonation delay? Then you must have forgotten that he has filed an appeal now. Loss of memory means that he is living in a state of bliss. Why do you want to trouble him? Good to forget, right? You have to assign reasons for condonation delay, Mr. Direct counsel for the appellant praise warrant is granted. How much time? Better affidavit. 2 weeks time to enable him to file a better affidavit. Thereafter. Better affidavit in support of application, support of IA 1 of 21. Appeal is admitted for hearing. Notice recorded. Same order. Same order. What objections? After Mr. Panindra, let objections, if any, on behalf of respondents be filed. Oh, Learned counsel for respondents submit that they shall file objections during the course of the day. It's on 9th of March 23.
Sports code, sir. Sports code.
Where is the order passed in WP, Mr. This is third rate petition. We have tolerated you for a long time. Now we will deal with the stern hands. So there is the order dated 10th of January 23 in your petition. Repeatedly you are filing petitions. This is an abuse of process of law. Unfortunate. No, there has to be an end to litigation. You you should have advised your client to prepare for the next year. Also. Fine. Please tell us. We have got incomplete facts. You had filed a writ petition, which was just a minute. You had filed a writ petition, which was decided on 10th of January 23. Where is that order? What was done to that petition? No. Where is the order? You are under a duty to disclose full facts, right? Not trying to mislead the court by just, no. Wait. No. This is third of. No. Sir. What was your earlier petition? How many petitions have you filed? Tell us chronological sequence. We are noting it down. No. This was your first petition. No, not. We are in the want to go back again to when we started playing these sports. So what happened? No. Tell us when first petition, first point of time, when it was filed by her, what happened? Him or her, we don't know. Who is he? He or she? She. So when was the first petition filed by her? What happened? Where is the order? This was the first petition. What was the prayer? This petition, 3rd of January, you have withdrawn. Before that, you didn't file any petition, correct? What was the prayer in this petition? What happened? WP 5/23. What happened to this petition? Where is that order? 10-2. Where is that order? Learned counsel. How much time? Learned counsel for the petitioner prays for adjournment in order to enable her to produce a synopsis with regard to the details of the petition previously filed by the petitioner, as well as the copies of the orders passed by this court, as well as by Honorable the Supreme Court, by way of a separate compilation. We don't know. Separate compilation. List on 9th March 23. Whatever we have said, though, all previous petitions, Mr. Comprehensively, don't say that I have separately chronological. Just a minute. What we want is first petition, what is the prayer? What is the order? Next, this thing about the copy. Second petition, what is the prayer? What was done to that second petition? Whether you challenged it in SLP, what happened, if any annex, I mean, for facility of reference, right? Otherwise, we will waste half an hour and eventually reach nothing. Don't say that I have already mentioned and I have annexed. Separately, chronological sequence. What all have you done? IA 1 of 20 requirement is distance with. You'll have to issue notice, right? We'll take it up on 9. Let them respond. Yes. Issue what notice on behalf of respondent 1 and 2 is accepted by 1. 1 is accepted by Mr. ASGI, Shanti Bhushan. And notice on behalf of 4 is accepted by Mr. Lakshmi Narayan, additional government advocate. Notice on behalf of respond number 5 and Rajiv Gandhi, Karnataka Examination Authority and Rajiv Gandhi. Mr. N.K. Ramesh and notice on behalf of Mr. What is respond number 6 accepted by so and so. Please see, we are listing it for consideration of prayer for interim leave after hearing you offers on 9th of March, right? Office is directed to reflect the name of the aforesaid aforesaid councils, right? 23 Mansi Kumar accepts notice. Office is directed to reflect the names of aforesaid councils. List for consideration of prayer for interim leave on 9th of March 23. After this framing of charge, we will hear habeas corpus. Don't call them now. Yes. And for the appellant, even when the matter is called in second round, Mr. So and so. Despite order dated 13/2/2020, the cost of rupees 50,000 on account of litigation expense been paid. It appears not interested. Prosecuting the appeal dismissed for want of cause. Payment charge. 23. What did you do for 5 years? Any explanation offered for not doing anything for 5 years, like which you are seeking to do in writ appeal? What is the remedy? File a review, explain to learned single judge that this is what it is. No. Tell us 5 years. What did you do? That's what we are asking. What did you do for? Either you have to furnish an explanation. You cannot. He has a constitutional right to hold the property merely because he holds the property inside or whatever municipal limits of Bangalore. He is not a thief. So you will issue a notification and he should keep on coming to your office all the time. This is what it is. Arey, mister, this is what it is. This is whatever it is. No, but he right to hold the property is a constitutional right. And you are constituted for the public, not with a view to harass them. Right? This is the approach, right? He owns the property. We will, all right, we will notify so that this poor man will keep on visiting and meeting your officers all the time. So when he, nothing, no case. The choice is yours. Either you withdraw the petition, file a review petition, or we dismiss the appeal. Choice is yours, because you have to give an explanation. Why you cannot play around with constitutional right like this. We cannot permit anybody. We have taken a view. We have quashed the proceeding. That order has been upheld by Supreme. We are very clear about it. That's why we, after arguing, this intra-court appeal has been filed against order dated 21st December 2020, passed in WP 14346/2020. After arguing the matter to some extent, learned counsel for the appellant seeks leave of this court to withdraw the appeal with the liberty to file a review petition against the order, against the aforesaid order. In view of aforesaid submission, the appeal is dismissed as withdrawn. Here's the aforesaid. What framing? What did you do? ATM. What the amount has been paid? Which date? Which date? Order. No, which order? He says some order sheet is recorded, right? Huh? Which order, mister? Where is it recorded? The 7/2/2020. What 10,83,000, 9 lakh? What was the amount due? Just a minute. What is the total amount? Each means total means what? Mr. Give up. What I know. Should we this thing? All right. Learn it. Just a minute. Learned counsel for respondent prays for short accommodation to enable him to file a statement, file a memo of calculation stating that stating that the amount due to the petitioners has been paid by the respondents in compliance of the order passed in WP number 796/2018. In addition, whatever next week. Contempt is contempt, right? Contempt is contempt. Then you may be sent to jail also, right? What? Your writ appeal, if your writ appeal is dismissed, you are ready to go to jail, right? Correct. No, determined means we will determine. No, Mr. Better pay it, whatever is due. Don't ask us to. We are not cost accountant, and we will see calculation. What is the amount and what is this? We are giving you one opportunity by way of indulgence. We are not going to sit with a calculator and find out what is the amount, how much paid, when paid, whether this is, we are dealing with contempt. You are on a sticky wicket. Be cautious. That's the word of advice. We don't know. You satisfy yourself that you have complied with the order. Fine. And then argue. Because it is, Mr. It is we will hear writ appeal also, this contempt also. Problem. Have we said that we have any problem in hearing? We hear day in and day out, we are hearing cases. There's no problem. Only thing is, we will hear the writ appeal and this contempt, and we will have to take a call. You better satisfy, we are advising you with that you have complied with the directions. We don't know what will happen to writ appeals. So once the order is passed, then this contempt will be decided. So before that, you satisfy yourself that you have complied with the order, whatever it is. We don't know. Right? Next week. 21st March 23. Fine. 21st March. 21st March. You have to make a chart. Make a chart that what is, how much is to be paid, and how much has been paid. That's simple. Yes, yes. 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 5 minutes, madam. There's nothing in the case. We know nothing means nothing to be argued, so to say. Yes. So for child has been forcibly removed from your custody without your consent. Which class? Student of which class? So student of which class? Which school? But what? You have not seen your daughter since? Yes. Any case? No. Is it a fact that you took away the child from Bangalore on 16/12? No. Whether the mother has met the child after 16/12/2022. No. Just a minute. Answer the question straight. It will go against your client. Please understand. Have you taken the child on 16/12/2022 from Bangalore? What you say that it has been done on the basis of a consent of the mother. Where is the order? Where is the any consent letter given by her? No, so therefore, where is the statement of objection filed by you? All right. So we are directing you to produce the girl child before this court, day after tomorrow. Produce the girl child, then we will pass in order, whatever order. We have heard. Got it? Produce the girl child. Not the presence. Heard learn it. Not day after, but on 9th March. 9th March you produce. We have heard learned counsel for the party that length. In the petition, it has been averred that respondent number 7 has taken away the child from the custody of the mother on 16/12/22. The custody of the child 16 from Bangalore. Full stop. His statement of objection in paragraph 8. It has been stated that the child was taken after her grandmother gave a permission to take the child for treatment. Full stop. Learned senior counsel for the petitioner submits that she has not seen the child since 16/12/2022. Full stop. The respondent number 7 is directed to produce the girl child before this court on 9th of March 23. List on 9th of March 2023. Produce the girl child. We will hear further. First produce. This is not the way. You can't be permitted to abduct the child. You produce the child. We will hear you on 9th March. It's not, argument is not yet over. We will hear you. Produce the girl child on 9th of March before this. No, 10th March. No. There is no timetable. Where is the date sheet? Which day? Every day examination. Don't tell us, Mr. Don't try to be smart. Don't try to be smart. Second, it's not a 12th class examination, right? 12th board every day. She's a 7-year-old kid. Don't tell us. Show the date sheet. Any order is an order, right? Go, give it. Every day. No. From 2nd March till 18th of March, every day is the examination. Whom you are telling, mister? You don't have an experience in life. You don't have a daughter. You did not have a daughter. You are a bachelor. No. We are asking you as an officer of the court, did you have a daughter? Are you a married person or a bachelor? Married, no. Do you have a daughter? You had sons, right? So you know when they appear in the 2nd and 3rd standard, what is the seriousness of the examination? Between 4th to 13th, there is no examination. See, this is date sheet. So you say has not seen so and so. Learned counsel for respondent has produced a date sheet of the annual examination. From the perusal of the date sheet, we find that there is no examination between 4th March 2013 to 13th March 2013. Therefore, the respondent number 7 is directed to produce the daughter before 9th of March, before this court on 9th of March 2013. Yes. Parties along with their counsel present in the beginning. Yes. No adjournment matter. No adjournment at any cost. So even if it is arrived at settlement, it is decided. Give it. 2013 matter won't be adjourned. This is the only case of 2013. We are sorry, it will not be adjourned. No. No, give it. No, nothing. No, they are not appearing. It will be decided on merits. Let them not appear. So 2013 matter, in no case, this is the only case, madam. 2013, 14 cases won't be adjourned. Everybody who is planning to seek an adjournment should forget about it. Our order is liable to be challenged before Supreme Court. You can avail of it. That the court, despite being told that we are compromising, did not adjourn the case. Do it. Nothing. So give it, madam, if it is signed. To produce it.
Fine,
Produce it. We will take cognizance. You are saying it has been signed. It's our duty to pass an order. It will not be. We are allergic to adjournment. It's the only case. Please understand, because of these few cases, the pendency is being shown that since 2013, MFS and the court, few days back, you have assured my lord that we will extend full cooperation in the. This is not the cooperation. 10 years, and if you don't appear, we will dismiss it. It will not be restored. We are telling you. You will have to go to Supreme Court. We will. Please argue. Then please feel free to argue today. Right now. Nothing. No 2013 matter. This is not ended. After 10 years, no adjournment. No. So why are you then involving? It's his problem. Like he should argue, not argue. Your petition has been dismissed. Why have you filed this appeal? But this is what does its appellant. You are standing at the place of the appellant. So, Mr. Yes. I think what Passover? What has been the compromise? He will give it. Give it. Show the compromise. It's not with you. Not. Where is it? Call the director mediation center and ask him to send within half an hour. If you can't, we will have to retire and tell him. If you convey the meaning that it should be here within, madam will take it up immediately when it reaches. Please be here. It will not be adjourned today at no cost. No cost. So we don't want to be morally wrong and we are answerable to our conscience. We will not adjourn the case. Come what may. Either he doesn't turn up. We will peruse the record, dismiss his appeal on merits if it is, or it is allowed. Whatever it is, we don't know. Either it is. We don't know. It's all your outlook. We don't know. We will, if he doesn't appear, still we will peruse the papers and decide it on merits. Even if you don't appear, we are telling you. But this is the last day of this case in the court after 10 years. And it's not that take up after only when you come. We may take up as soon as the mediation is. Whatever. If that's your outlook, we will not advise what to do. We have told. But even if you don't appear, it will be decided today. Hearing you, without hearing you, choice is yours. If you want to be heard, remain present. His choice, he may disappear. His appeal, whatever will happen, will happen.
It's agreed by 130. Before that, just now you will come.
half an hour ಅಂತ ಹೇಳಿ.
Yes. Mr. We have heard you, right?
അവർ ഒരുപാട് ഞാൻ പറഞ്ഞു ഞാൻ കേസ് എടുക്കുന്നുണ്ട്. വലിയ പ്രഗത്ഭനായ ഒരു എഞ്ചിനീയറാണ്. പുള്ളി അവിടെ ഒരു
After these two cases, 2013-14 would be over, Mr. Mehta.
ആ സ്കൂളിൽ ഒരു ഫംഗ്ഷനെ വിളിച്ചിട്ട് ഞാൻ 10,000 രൂപ
First thing, they are not following how it would be. That's why we told you that if you can't speak, we will speak. That means an order of the court. Whatever we say sitting on this chair is an order of the court. Anybody violates, including ourselves, they are guilty of contempt, right? Can't. Yes.
ഒരുപാട് എന്റെ വീട്ടിലാണ്.
Yes, yes. Yes. Yes, yes, argue, please.
വണ്ടി വിടാമോ? ഞാൻ പറഞ്ഞു വണ്ടി ഓൾറെഡി ബുക്ക് ചെയ്യാം, ഞാൻ അങ്ങോട്ട് വരാമോ? അപ്പോഴേ ഇവിടെ വെയിറ്റ് കാണിക്കുന്നു. നമ്മുടെ പിണറായിയായിട്ടും വീട്ടില് വലിയ ഇത് അഡീഷണൽ ആ കേസിലാണ് 9 കോടി രൂപ
Punch.
Because this very fast government they are not once you are not P60. We can everything. This case. The conversation, the appellant and the variance of the response. I think with the 61 and they do not, the argumentation itself is not entire case of the
You have produced it in evidence. Has it been proved in accordance with 65B? What is it? You tell us. What is it? It's not like, I mean, first appeal is not giving a this thing to pen drive to the court, and this is the entire case of the appellant. The operation of the court. Please argue.
That has to
65B. C65B. Argument of 65 has to be proved. It can be otherwise not admissible. What the family court has said about this CD?
Because the family court not at all have the entire CD. This is saying that not women is grey. That's the reason not the incident taken place in husband house. It is entirely established in that CD. She, her parents scolded the respondent not to behave like this. The CD, entire CD, she also admitted. Very similar in her evidence. He admitted the recorded CD. He also admitted. That is so much. Even then, not backward, not CD entirely was an order. The last examination respondent. Then particular question I will ಅತಿದಾರ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ ಸಿಡಿ ವಿಚಾರಣೆಗೆ 14ರಲ್ಲಿ ನನ್ನ ಮತ್ತು ಅತಿದಾರರ ನಡುವೆ ವೈಷಮ್ಯಕ್ಕೆ ಕಾರಣ ಕುರಿತು ನನ್ನ ತಂದೆ ತಾಯಿ ಸೇರಿ ನನ್ನ ಮತ್ತು ಅತಿದಾರರಿಗೆ ಮಾರ್ಗದರ್ಶನ ಸ್ಟೋರ್ ಮಾಡಲಾಗಿದೆ ಎನ್ನುವುದು ಸರಿ. The entire CD will not. What are the clearly I explained to the parents. Parents are scolded, saying that not to do like this.
Workers in the union leader under the
What's it is CD.
We will take care. Don't worry. You argue, Mr. If you want us to see the CD, that's all. Then we will hear it. All we will see. Yes, Mr. Then you are insisting that one CD. That means we should see the CD. Without that, you will not proceed. You conclude, Mr. It's CD is only a piece of evidence, Mr. That does not dispense with the requirement of arguing a case. Otherwise, then it's very easy. Both the counsel should give us CD and then not appear. It should also, why there is no need to sit here. We should only see CD in our chambers and decide cases. If that is so.
When I started the search, About 11 p.m. Both we opened the door and my house was not going to be. But on the day, my house was present in my house, and I questioned the respondent why she is my house without my notice. Then I responded that
അതിന് അതിനകത്തുള്ള വേർഡ്സ് എല്ലാം ഭയങ്കര പാടാണ്.
Relevant portion only missing. It's not an out of the case, out of the world case, right? It's only cruelty, right? You are seeking a decree on the, what is it? What's the difficulty? Please go ahead, read the relevant portion only. You every time you start looking at us. Please, we are hearing. Go ahead. It's not a case out of the world that we are doing Keshwanand Bharti's review. Nothing like that. Simple, right? Cruelty. Go ahead, we are hearing you. We have heard you for 40 minutes the other day also. We are hearing you today also. Go ahead, don't look at us. Argue.
Number 5. Also, the respondent started guilty. Also, when I returned to the house, so the respondent used to quarrel with me. My parents silly reason, creating a scene at house. To defend or dignity when the behavior attitude the respondent went beyond government limit. And next paragraph. I submit that when the next day of morning, this Monday, took her to Davangere, while on the way, she again picked up quarrel and she tried to open the running car so near Munali, saying that I will jump from the running car if you are not decided to agree my words and rules. Then I put the hand with the left hand and to the car vehicle, the single hand up to Davangere, which is very much difficulty. And I left the respondent in their parents, and I asked them to give proper advice to the respondent not to do like this. This one, as I stated, on that day, actually 16 years ago, the front of that father and mother, the discussion with father and mother, and the father and mother will not agree that the respondent behavior. Page number 7. She used to threaten the top when not. She used to threaten that she in false case, you file a false case before the police and my parents and the sent to jail. On the same day, I called their parents and came to my house and made a and going to the staff. And the second this is important in the then also respondent provoked me by totally with hands. The respondent by I was sleeping. Then I got very released. I go the parents of the respondent. I informed the said and I said I am unable to talk this
marriage.
I am unable to
Yes,
continue
it is.
my profession being a doctor.
Yes.
Next paragraph. I suffered great mental. I was unable to pursue my doctor profession. Hence, working 8 to 11, I resigned my job down here and also Shimoga. And presently, I am sitting with my parents and not doing any job.
Hello.
Page number 9.
Yes,
Submit that I am not doing any work. The respondent and family members, particularly financial support, not to give any job wherever I joined the job. Moreover, I was accused by the respondent by filing 2 false cases before Kotak police station, Villa police station, against me and my family members. Now I am unemployed. I have not done any job. As such, no source of income. This will not for logic. False police.
I think this is the 2013 volume 5 is 226. 2013 volume 5 226.
This
In
is
this case of the single facts. She used to file a complaint. Even then, after the record, proceedings and parents and all. And she used to file an application by application to the trial court and grant the proceedings. Since from 2011 till today, Malad, she filed an petition to the High Court Malad state the proceedings as husband. And it's 12 years, Malad, he's roaming to the court. Each and every time, Malad, he has to appear to Davagere. And she is driving the proceedings.
this criminal case is cast against everybody.
No, as a husband, it's
Pending.
Because she is filing since from 2011, she is filing the application. Even then, the Honorable High Court passed the proceedings as arranged. And now, she is filing application to the High Court and the parents also. And she filed when the matter for argument, and she filed one more application saying that not the addition document. And the court rejected the application, then filed a writ petition, criminal petition before the Honorable High Court, not pending to the and only dragged criminal case. So once the criminal case is completed and he has no case at all, that is the reason he is dragging the proceedings before the trial court. And I filed additional document degree.
I will ask on the answer that is coming. I will give to him.
Additional document.
He is coming actually. I told him you can come and have it like that. No problem.
27.
Okay, he is coming. I will just present it to him. They also want me to use.
The documents are not updated now.
Okay, sir.
She came to my workplace and assaulted the singularly may not the parents and the influential person, the father of the respondent is a very influential person. That's why he came to my house and threatened left that. That's the reason I filed a complaint before the police, and he gave an endorsement saying that I will not come to, henceforth I will not come to the place of the respondent. We will look after the case before the matter court itself. He gave more than 3 cases, more than 3 times my lord, and once my lord, wife, that's the only workplace. That he's a doctor. He, in front of all other doctors, she asserted, and
You are telling us for the second time today. Just 5 minutes ago, you said she assaulted him. Same thing. Go ahead. Don't time in. We have understood that you want to prove cruelty by saying she has filed false and frivolous complaint and has assaulted you in your hospital or clinic, wherever in front of others. What else?
more than
SC 100 of 2014, no? SC 100 of 2014. Against you, it is continued.
loss of job not because the apartment issued many committee. The influence there are apartment. Now, my lord, I have to look after my age period. Whereas, I also she's cancer, and that's the reason, my lord, nobody is. I'm only son, and she's used to have like this. I'm not able. I have to work. I have to look after my parents. They give me 12 years. I'm facing the child without my more than 8 cases could be solved. Not. And 2 cases is pending, and I'm paying maintenance also. Regularly, I'm paying maintenance. She took contact for thereafter, my lord, she said that my lord forcefully aborted. Even then, my lord, after abortion, she conceived, my lord, the baby delivered. It is in custody of the respondent person. She is not allowing us to see the child. And it is the after that, after filing this case, he filed a one more false complaint, not abortion. It's 1.5 years back incident. She filed a complaint to go to the saying that not forcefully aborted. And then thereafter, one more fail is there because her she used to taking unwanted tablets. That is the reason, as for the doctor advice, it was aborted.
ಕ್ಲೋಸ್ ಮಾಡಿ ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ ಅದು ಈ ತರದ್ದು ಓಕೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ I suggest that the media is already uploaded. These are the comments.
She is MBA graduate. She is having a good degree. Master degree, my lord. And the respondent very well. That is the reason, my lord, she is doing all this action. She is well off, my lord, and support of their father. Only 2 daughters. One father is only 2 daughters. One is married. She is parents. After the lapse of 12 years,
That's of the case. It's not.
ನಾನು ಆದ್ಮೇಲೆ ರೆಡ್ಡಿ ಸಾಬ್ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಇವತ್ತು ಕ್ಲೋಸ್ ಮಾಡಿ ಎಲ್ಲ ಸಜೆಸ್ಟ್ ಮಾಡ್ಬಿಡಿ ಇದು ಮತ್ತೆ ನಾನು ಆದ್ಮೇಲೆ ಕವರ್ ಆಗ್ತೀನಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಏನಿಲ್ಲ ಏನು ಆಗಲ್ಲ ಅದು ಮೀಡಿಯಾ ಸೇರಿದ್ರೆ ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಕೂಡ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಬಂದಿದೆ
The division bench has held that.
ನಾವು ಸೈನ್ಸ್ ಆಗಲ್ಲ ಮತ್ತೆ ದೊಡ್ಡ ಪ್ರಾಪರ್ಟಿ ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ ಸೇರ್ಪಟ್ಟರೆ ಸಾಕು
It's also
ಜಾಸ್ತಿ ಬರ್ತದೆ
he's doing all this action. Year 1994 Supreme Court, made him a 710.
ಅಲ್ಲ ನಾವು ಫೈಲ್ ಮಾಡೋದಂತ ಖಂಡಿತ
710 94 Supreme Court.
ಅಲ್ಲ
What is para 70?
ನೋಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಸದಸ್ಯ ಕೊಡಿ ಸದಸ್ಯ ಕೊಟ್ಬಿಟ್ಟು ನೋಟ್ ಮಾಡ್ತಾರೆ
Broadly, we define that.
ಅಲ್ಲ ಅದು ಬೇಡ ಅದು ಮಾಡಿ ಇದು ಮಂಜೂರಾದ ಬಾಕ್ಸಲ್ಲಿ ನೆಟ್ಬಿಟ್ಟು ಸದಸ್ಯ ಮೀಡಿಯಾ ಈ ತರ ಇದಾಗಿದೆ ಸದಸ್ಯ ಮೀಡಿಯಾ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬಿಡಿ
Expected to live together.
Okay.
The execution must be such that the wrong party.
ಬಂಧುಗಳನ್ನು ಹೇಳ್ರಲ್ಲ
Society, they move on. Ever living together. Yes, already living all the other relevant. Participability in one case may not be in another case. It is each case having regard to the facts and circumstances.
Yes.
It's a case of
Correct.
and application regard must also be at the maybe in my case, social needs a doctor. Social he gets she can all other time. Because the exhibitor they themselves document the exhibit. She gave my workplace and contacted all my patient, all details. She produced one all certified, saying that not she herself CD. And she admitted that not wherever I would and work, she used to come and disturb the collect. A document not kindly see not required. Also the these documents clearly established not she taken the patient details. She produced before the court. Saying that Lord, I am working there. I went there in front of those patients. She recorded the entire video wherever I was working. And the second judgment yes, multiple Supreme Court. Is right by this case may not she used to go to the higher authority. I cannot he used to disturb wherever I was working. And also filing a criminal case against parents and teachers. Also against me. Third judgment not page number 80.
ಇದು ಒಂದು ಪ್ರತಿ ಇದೆ.
This case also will not, both are doctors. Both are doctors will not, and she filed a false complaint as well. More than 8 cases. And that too, people cannot not believe that their social status and all, they are taking a dowry. And anyway, 2 of 2012. Last 6. The judgment. Page number 13. Sorry.
You read it, who's preventing Mr. This? Every time you ask, should I argue for the? They are waiting for you to conclude. It's over an hour now. Yes, go ahead.
See, 4 years after the marriage and 1 year after giving birth, the son only disclosed that only to harass her, to let her also finish the not and the opponent and other members of the family that is considered by their family background and status in the society, immoral, they just we are of the opinion that the same amount of mental
Who is with daughter is with whom? Your wife? What is her age? Daughter's age? The judgment which you have read. 5 minutes more. Look at the watch. Don't look at us. Watch 5 minutes more. 40 minutes on that day. Now half an hour today. We can't give more than that time to a counsel to argue on cruelty.
Para 6 and 7 judgment you have read. Para 6 and 7 filing false cases.
Suppose that lot is having show the exhibition. It's a complaint alert. I had a complaint against the parent. Then they are not with alert. It's very clear. The police authority gave an endorsement saying that they have not come to the police give an endorsement. People respondent father. Tell them ಇದು ಸದೈವ ವಿಚಾರಣೆ ಮಾಡಿ ಇದರೊಳಗೆ ಹೋಗಲ್ಲಪ್ಪ ಬೇಡಿಕೆ the respondent lot used to come to hospital all exhibits. They collected document, photograph, patient's record. She collected the record from my patient and produced the report. And she also given endorsement for the police. Take the blood will not come to ಫ್ಯಾಮಿಲಿ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ನಡೆಯುತ್ತಿದ್ದು ನಾವು ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿಗೆ ಬದ್ಧರಾಗಿದ್ದು ಹಾಗೂ ಹಿರಿಯರು ಸೇರಿ ಮಾತನಾಡುತ್ತಿದ್ದೇವೆ. ಇದನ್ನು ಮುಂದೆ ಅವರ ತಂದೆ ತಕರಾರಿಗೆ ಹೋಗುವುದಿಲ್ಲ ಹಾಗೂ ಅವರು ಕೆಲಸ ಮಾಡುವ ಜಾಗದಲ್ಲಿ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡುವುದಿಲ್ಲ ಎಂಬುದಾಗಲಿ ಮಾಡುವುದಿಲ್ಲ. police she make the predict that not he will not come to find the place or only one time, it's a several time. And exhibit P8 is may not the December High Court order. The additional document will not is after the all document citizen will not have even till today that harassment is going on, harassment is going on even till today. Is asserting the criminal case saying that one or the other way to harass the CD will only part number 3. The learned part 1 to only part 1 to not part 3. It's a very clear. They admitted what all the act of the respondent. Part 3. Part 1 will not cease crying when I get into her house. She was crying, and the part 2 also will not. It's a real portion of the CD. The CD. The first part area. Part of 6.14. 6.4 and 5.15. This part 1. In part 3 is concerned, entire conversation is very clear that not the entire harassment and all it is recorded. And she is also suffering thyroid related issue. These are all the act of the continuous act of the respondent. I'm not able to properly. Even then, one of the incident when he started the patient, he used to call the hospital saying that I have to come back, otherwise I will commit suicide. This act of the client. It's a frequent act of the client. The client is not able to continue. And 12 years they are basically separated.
Yes, Mr.
It's submitting of the judgment. And the petitioner has also very admitted. One is that for reading judgment, reading life to was there at the instant of the response. Over as the CD, that it is not taken into record by the honorable high court. There's a clear finding. Honorable high court page 19 of the judgment. It says that at page 90 of the judgment, one woman is trying to other person. One of the things is that woman is taking it's true that you know
No, whether you have given the certificate.
unless CD is considered that we keep a virgin record, it's produced with
All right, all right.
page 91 of the
That is.
All right. Yes.
It is not all. After that, second, because I am a doctor. Here, the second pregnancy is one child is there. She filed a complaint after 1.5 years, 2 years. She filed a complaint, false complaint saying that not the cost. That's why the Lord she is dragging that case, and not the other way. It's a matter of course of argument. Even the Lord is pending.
That's it. Anything else?
Property, family property. Family property,
Display. ಇಷ್ಟೇ ಮಾಡಿಸಿ.
agricultural land purchase ചെയ്യുന്നതിന് നിയമമുണ്ട്. സ്വാതന്ത്ര്യ നിയമങ്ങളുണ്ട്.
Board display ಮಾಡಿಸಿ ಅವ್ರ ನೇಮ್.
ಬುಕ್ ಮಾಡಿದ್ದಾರೆ.
Display board.
അതുപോലെ തന്നെ ഇവരുടെ വിനോദ
ನೋಡಿ ಅದೆಲ್ಲ ನೋಡಿ ಅವ್ರು. ಇಲ್ಲಿ ಇಡಿ ಎಸ್ ಕಮ್ ಸರ್.
She doesn't know. Mr. Nataj, help her. She doesn't know. Ask the presence of the council, let them know. Yes. It's a fee. Under section 28 of the Hindu Marriage Act has been filed. Amendment and dated 2013. Passed in MC number 30/2010, by which petition filed by the appellant seeking resolution of marriage on the ground of fidelity has been discussed. Paragraph. We have perused the memorandum of agreement arrived at between the parties before the Bangalore Mediation Center. The aforesaid memorandum of agreement has duly been signed by the parties as well as their counsel. Of the terms and conditions. Paragraph number 2A. From here. In view of compromise arrived at between the parties, the marriage performed between the appellant and the respondent on 15/9/2004 at Arya Samaj Temple, Madhya Pradesh. By a decree of divorce, and the appeal is disposed of in terms of compromise arrived at.
Indian law institute
Your name, right?
അങ്ങനെ 9 അംഗ കമ്മിറ്റി ആ കമ്മിറ്റി ഓരോ ഇതിലും ഓരോ വലിയ വലിയ
ಪ್ರತಿಮಾನ
സ്കൂട്ടിനി ചെയ്തിട്ട് അതിന്റെ പോയിന്റ് മാറും. ഓൾ ഇന്ത്യ പബ്ലിഷ് ഇന്ത്യൻ ലോ ഇൻസ്റ്റിറ്റ്യൂട്ട് അത് ആവറേജ് ഇത് ആനുവൽ സർവേ ഓഫ് ഇന്ത്യൻ ലോ ആനുവൽ സർവേ ഓഫ് ഇന്ത്യൻ ലോ അത് നമുക്ക് സൈബർ ഓരോ
Forget about that journey. No. Nothing. Don't appear. Don't appear to seek adjournment.
പോലെയോ അല്ലെ അതിനെ പറ്റിയോ നമുക്ക് ഞാൻ ഇത്
Nothing. We have appointed amicus. We can hear the case without her also, right? It should not be a ground. He had appointed for our assistance. If she is unable to render us, fine, you sit down. No obligation for you to appear and to seek adjournment. Nothing. Appears for the applicant. So the the facts have already been stated here. Family judge dismissed. Let's see what's wrong with the thing. Paragraph 8.
Yes, yes.
ഇല്ല അവർക്ക് എല്ലാ സബ്ജക്റ്റിന്റെ ഇതിന്റെ ഓരോ ഇതില്ലേ ഓരോ ഇതറിയാമല്ലോ
Case.
We affirm the defeat. Yes. All right, none for the parties. Record perused, reserved for this.
Yes, no.
This was the last case of 2014, madam. That's why we did not adjourn.
Taker has heard she's amicus.
She's not amicus, amicus junior.
Yes,
We
really.
can't.
The response is not no problem.
No.
ഇത് ചെയ്യുമ്പോൾ നമ്മുടെ
Service they
Ah.
are.
20.
Yes.
Yes, 50 cases. 34, 35, right? Disposed of, madam. Your appeal has been disposed of. In terms of the compromise arrived at between the parties, it has been. You give it. Otherwise, you can file an application for recall. No, it has been disposed of, right? In terms of compromise, we have got the report. We have granted, madam.
Yes.
So you pay, Mr. We will record in the order sheet. Madam, learned counsel for the appellant undertakes to this, before that, in view of agreement arrived at between the parties, before that, learned counsel for the appellant undertakes to hand over the two demand drafts, respondent as well as the child son on or before 9th of March 2020. This is recorded. Marriage is dissolved, petition is disposed of in terms of compromise. No, you may find it to be little unreasonable, but no, because this was the last case of 2013 and the last case of 2014. In none has appeared, we have reserved it. Because these are the only two cases pending of 2014. That's right.
Finish the process.
Yeah. All right. Understand, right? Huh? Demand draft to be handed over, otherwise you will go where? You don't pay the demand draft, hand over demand draft, you will end up which place?
Personal.
No, which place? We are asking you. Your client will end up where? Ah, correct. Take the payment.
In this media case,
We have said, we have recorded statement. He understands. He as well as you also. Both of them, both of you can stay together there also. Because this is a statement made to the court, correct? So when you make a statement to the court and don't follow, what happens? Contempt of court, correct? So therefore, what is the lesson? That if you ask correct questions to yourself, you get correct answers. You have got it right on both the occasions. That your client will end up in jail, and this is also contempt. And contempt is understood, right? 9th March, you should hand over the demand drafts. Huh? 36. No. So what I mean, they don't plead evidence and make the client appear. It should appear before the medical board. We are not doctors. We don't know. What is? No, Mister. I mean, see, this is the problem. If we ask a question to you, you will have this thing instead of leading evidence, producing evidence. Ask the client. We did not. Did you? Is there an order asking that? What is? I mean, are we doctors? How do we ascertain looking at him what a disability is suffering from? We don't know. We don't know. It may have been imputed. Whatever. Don't call him. Don't call him. Don't call him. We have not called. The court has not called him, and it's you deal with him. Whatever. If he has come to pay fee to you, recover fee from him and be happy. In any case, it's our job to decide the case. That we will do. Why should you have called him unnecessarily? See, Mister, what transpires between you and your client, we are not concerned. It's all privileged communication, right? Understand? Huh? You take care of your client. Whatever is here, we will decide in accordance with law. Whatever. As per instruction, respondent has not paid. You have paid. No. He had asked you to file an affidavit, not asked him to remain present. This all. No, you have to, Mr. You disputed, you said that it has been paid. We have asked you to file an affidavit, not paid. Huh? Fine. So on instructions you are submitting is not is paid. This is not criminal appeal, this is MFA. Yes. Huh? They not paid. He is telling no, you argue now. This. It's a case where you are something involved in a cooperative society movement, you are a leader. It's that case. You some case you are appealing, right? Different case. He is auto rickshaw driver, no. Farmer. Yes, please.
Why 15, 16 years they are living separately. Alimony can be given.
So I mean, you see, you can't stay with him right now. Can you stay with your husband now after? What? So supposing that if that amount would have been doubled, right? 5 lakhs. 5 lakhs. Advise your client why to end this. He's there, you talk to him and put an end to litigation, right? They are agreeing resolution of marriage. And see, you have a daughter, you owe a moral responsibility. It's not that you are giving it to your wife only. You are a father. There is a daughter also. She needs to be looked after. So 5 lakhs. Pay. Let us know. We'll take it up after a while. Let him talk to his client. Instead of bringing him here, you should have talked, right? Yes, he is present. Talk to him and let us know. Yes. Yes. Yeah. 1 minute.
37, 15 network, can we name it?
What about arrears of maintenance? Huh? Was not paid. Responded. For 621, it's going on.
That's it.
38 minutes. Appellant is not there. We see it in second.
Your Lordship, the serial number 38, I appear for the appellant, Your Lordship.
The ground of guilty and desertion. Guilty only. What is the date of marriage?
ಈ subject ಇಲ್ಲ. ഒരുപാട്
It's when you are living separately. Then, madam, what do you think? 19 years. Any hope? Possible, right? Realistically speaking, any children born from the marriage? Two. Huh? Daughter, what is the age? Married? No. And son? They must be studying now. Oh, mister. What do you? No. What do you do? Farmer. What is farmer owning how much land? Right, I mean, madam, how much amount of maintenance your client expects? Okay. No, you will have to, mister, please understand, you will have to pay permanent alimony or alimony in any case. She is your wife, right? There's no, I mean, there are no chances of their living together. Now your client is almost 50 years of age, above it. So obviously, madam, I mean, practically 20 years you are residing separately. Overnight, miracles don't happen, right? We should believe that miracles happen, but it's very difficult. And you take a call. We are here to decide the appeal on merits. Nothing we allow or dismiss. That doesn't make any difference. Result of this appeal doesn't make any difference. They are going to stay together, away from each other. That's a gospel truth. Whether we allow it or we dismiss it, do whatever. At the most, so, sir, what do you think? You ask your client. You should have asked. No. What is when you when we ask, then only I will ask my client. No. Hey, Mr. Two children. No, but what happens to your children? They have grown up. Marriage, what will you? Marriage also, you have to, will you not perform the marriage of your children? Then who will? No, undertake, who has seen? Undertake. Supposing if you don't give a penny at the time of marriage, will she be running after you and filing execution? No. All this you consider, Mr. Huh? Find out, Mr. Advise your client. It's always better to buy peace of mind. There's no point. I mean, we told you what we can do. We will allow or dismiss. The result doesn't make any difference in their lives. They will continue to live separately. Please understand. It doesn't take, it will take 15 minutes for us to dictate an order right now. What is there to find out? We deal with so many cases every day. There's nothing great about it. Why it has been dismissed? But see, this decision on merits will not help you. So obviously it will be withdrawn, Mr. Obviously it will be withdrawn, provided you advise your client properly. If you tell him that don't pay more than 4 lakhs, I will take you to Supreme Court, then he will, all right. These cases require a different approach. These are human problems. It's not strictly law. Human problem. The fact remains that you have 2 children who are of marriageable age. Your wife is living separately. You are 51. And what happens if we allow her? Supposing if we dismiss, what happens? Still, she will file another case seeking maintenance. You will have to pay that. The law is in the favor of, I mean, you know, in whose favor it leans. Like, better to buy peace of mind instead of, you won't get anything in litigation. For us, it hardly a matter of 15 minutes. We will hear you for 5 minutes, see what is the finding, we will dictate the order. That's not the solution. Talk to your, she has given an offer, right? You talk to your client and let at least know his response. That obviously, if you agree to pay the amount of alimony, they will have to withdraw the case. Please tell us.
Please, my lord. I represent the appellant in this matter, my lord. My lord, they are living separately for the last more than 15 years, my lord.
Oh, 40.
Yes, my lord. They are living separately.
41.
40, my lord.
It counsel for the appellant prays for accommodation to enable him to seek instruction based on 21st March 23. See, Mr. Works. 100%. Can't be any reason. Moment we, by mistake also, we say a date bound to oppose. Why? Estimate 21st March.
Second is already is going.
What date? You tell us. 27th March.
Party, my lord. Serial number 40, my lord.
Mr. So-and-so learned counsel submits that he has filed wakalat on behalf of the appellant. However, his name has not been reflected in the cause list. Office is directed to reflect the name of so-and-so as counsel for appellant. Learned counsel for parties jointly pray for adjournment to enable them to report settlement. List on 28th March. Party 3.
that every person. Yes, opinion. Three doctors he has examined.
No, nothing. Arguing. We have heard it. You are senior counsel. Ah,
You can come, sir.
you can conclude. Yes.
Mahesh, you can. Anytime ask your senior to.
Hmm.
Just any place.
Doctor. Ah.
Even before examination, they have examined the respondent. And that is also recorded in the exhibit page 23-24. Now the opinion of the doctor is that it is curable and now he is all right as of the date of examination of PW 3 and 4. Even before giving evidence, she has been subjected to examination. That is the finding of the trial court. This is the curable disease. Now he is all right from passage of time. The child is also with the mother for 2 years. In between, the child was sent to along with father also. There is no complaint by the child. And you have the Supreme Court judgment in case of schizophrenia, the curable disease. The husband has to look after the wife. Therefore, it is not a ground for divorce.
Kalam Chandrasekhar.
2014 1 year.
Kalam Chandrasekhar.
In this statement, Supreme Court elaborately considered the effect of schizophrenia disease not permanent disease. And from passage of time, the respondent is now behaving normally. There is no continuation of that disease. Therefore, in that statement, also finding of a trial based on the evidence of PW4, that is Venkataramana. When examined as PW4, just before that, he had, as per the direction of the court, he had been subjected to examination. So only on the ground of schizophrenia, curable disease here, there is no marriage of staff. Trial court finding at page number para 14. We read that relevant court finding of this. Right. Internal page number 14, page number 27. Para 14 relevant court, the finding of the trial. PW 3 and 4 were clear examined and there was no passage condition. Here, PW 2 study, Venkata Subramanian was subjected to pass examination. Kindly see, then pass examination of PW 4. Of the sentence. In 1915. Second page. Page number 23. Paper copy. And first is the suggestion. It is true to suggest that the condition of the present patient is reasonable. Further, with continuous and regular follow-up with mental health professionals, medical medicine, advice by them is proportionate curable. He admits it. Today I have seen the patient. Very important. As per the medical clinical observation, patient by Kusma does not have any overt behavior manifestation of severe respiratory symptoms and he came immediately for the clinical assessment. He was conscious and cooperative. Further examination, I did not observe the patient to have any delusions or illusions. Her mood was normal. He predicted he appeared having had a symptom earlier and now currently he reported to maintaining well. Further, he attributed her improvement to regular treatment before immediate treatment on
with 200 mg tablet, so moreover, she is willing to take further treatment for the advice of the doctor. In view of all these observations, we encourage about the current psychiatric state is that he is currently 50. Okay. And they have examined PW. In view of this, this was examined, given examination 2015. From 2015 till date, what state was with her, and there was no complaint by the state, and state was already before the trial court. The value was twice. And kindly, this is the finding of the trial court also. And the date was present, and he was asked the question about the status of the mother also. He said that he is not. Finding of the we put paragraph of 15. Para 50 is the observation of the family regarding the medical level. Therefore, as of that date, as of today, and as of date of exam is normal, and then we see the exhibit B 23 and 24. This is the finding of the family. Final opinion is also written by the doctor PW. The 8 of that 320 internal page 8 segment. Personal judgment, page number 8. Start. Personal judgment normal. Initial judgment normal. On the basis of this, the trial court is not on the date of critical. It is not the case of the that number of the normal now. Both the parents are attending the function.
But a daughter is there. Daughter from the. What is the age? Son. Hey, Mr. Don't read from place it.
And 13 and 40. As per the doctors who have been examined in that case of, they have said, complete and relevant process. It is just clear that the respondent, even if he reads about from his low feelings, in such a case, better health condition present. Therefore, this court cannot grant one so basis of one score in this. The appellant has not proved that the written disorder of respondent to reference to allegations made against her. And we are been coupled from the schizophrenia by producing the form of positive and substantial evidence. Para 31, the doctor who had been examined there also, he said, the schizophrenia has become eminently treatable with the adverse effect of many new psychiatric drugs. He further stated that many patients with schizophrenia are able to live near normal life with medication. On the basis of this, schizophrenia is curable. Favors cannot be granted.
Thank you. Great. Corporate. All right.
Even correction.
Starting question. Huh? Why? After 7 years, why do you want to build up? It's time to give up now. Nothing to build up. Nothing will happen. Who is asking you whether anything will happen?
അറിയാൻ പറ്റുമോ അതിനകത്ത് ഇലക്ട്രോണിക് ബോർഡ് ഇല്ലേ ടൂവിൽ നോക്കിയാൽ മതി.
She is 14%. You live in Bangalore, madam. She comes all the way from Bangalore. No. Mr. See 1st of March 23. Order sheet. That day also same argument, right? You don't even know what have you. No, how many? Please, Mr. Gupta, 1 minute. Listen to us. She is a party person coming from Bangalore. 1st March she came. You said the same thing and got an adjournment. We adjourned. Today also same thing. Better. Your file is lost. Client is also lost. We will hear her and decide. There is no. That's why we said in the no. That's why we said in the beginning that it is time to give up, not to build up anything. We are reaching at such a stage where we should practice renunciation and start giving up so that we are happy. Huh? What can be? We cannot. How many times she is the litigant? She is appearing in person. Comes from Bangalore. How many times we will tell her this? No. Huh? You go through the yes, madam. Should we grant him adjournment or you want to argue? We will grant you adjournment provided she agrees, because she is required to travel. We have no problem. Yes, madam.
Cost of traveling.
Cost of traveling.
She got only Bangalore. She's in Bangalore only. She's very beginning. She's not making. So like, okay, after you are slowly.
No, Mr. Gupta. I mean, if you really want to take it seriously, no, seriously further, we will conduct an inquiry. And if it is found to be false, she will be either, you will be in trouble or she will be in trouble. We are, leave the case up aside. We are only interested in finding out. If you are only interested, then if we find out, if she produces a ticket of having travel to Bangalore, then you will be in trouble. Don't. This is High Court, Mr. She can say, but you cannot. You are an officer of the court. You appear here to assist us or to create obstruction in the administration of justice by seeking adjournment and by talking all what is not relevant. How is it relevant? She is a litigant. She has a right to argue. Madam, Yes, you
No
want to
trouble
argue
out in
today? He is seeking an adjournment.
court language
So we will. All right.
bullshit എന്നൊക്കെ പറഞ്ഞു.
Fine. So if you want Mr. Gupta adjournment, you will have to pay the expenses of traveling. If you don't want to pay, then argue. She is willing. Tell Mr. Natraj. Tell that she is ready for an adjournment provided expenses for traveling. You can go through in the break. You can go through the record. Mr. Amicus, tell him he can go through the record in the break. Yes, madam. We'll begin at 1:30. After the lunch break, 2:30. Afterwards means not on another day. Mr. Gupta, today itself. Not possible then. Whatever. Reasonable cost, she said no, she is traveling from Mangalore. What are the expenses, madam, from there?
Past you have to say, no? What is the past you have?
3,000?
Yes.
3,000 rupees, 5,000 pay. No.
Stay and food and all.
This is not subjected, Mr. This is not subject to bargaining. Either you argue or pay 5,000. This is not, we are not sitting here to bargain. Will you pay? What is the date, madam, according to your convenience? Which date? Tell us, you have to come.
We'll ask Mr. Gupta only. When he will be
What
ready.
date you will be ready? No. This is 2016 matter, Mr. 7 years. No. Mr. Gupta, you have to be reasonable. That doesn't mean that looking to the age, your age, we are since giving indulgence, that means you will say anything. No, whatever. No. We will fix a date. If you can't argue, your colleague will argue. If you can't appear, then we will decide it. Expert. Tell, man. Tell. Just tell madam your convenience. Next week. No, don't make up. Don't build up. Oh. 7 years, Mr. Gupta, 7 years. We are not concerned. No. Looted means we are not interested in looting. Just a minute. We want to decide this case in accordance with law. Your chamber has been looted, has nothing to do. 7 years, Mr. Enough of it. No. Madam, we'll fix it on 27th March. Fine. 27th March. Party in person. Mr. A.S. Gupta, learned counsel for the appellant, once again prays for adjournment. The aforesaid prayer is opposed by party in person on the ground that she has travelled all the way from Mangalore. Paragraph order sheet indicates that on 1/3/23 also, Mr. Gupta, learned counsel for respondent, had sought an adjournment. Stop. By way of indulgence, hearing is deferred subject to payment of cost of rupees 5,000 to party in person. It is made clear that no further adjournment shall be granted. List on 27th March 23.
Third and client ആണ് lady.
അല്ല ഗുപ്ത റെസ്പോണ്ടന്റ് അല്ലേ?
ആ. They are all connected. Right? When do you want? So they are all connected, right? Hey, Mr. Connected. Then, Mr. What do you say? I mean, he's praying for it. He's opposing the prayer. Suddenly, last date it was this. Don't at 134, Mr. He's opposing the prayer. What can be? You convince him? No, it can't be. You file an application for delinking, assigning reason why it should not be heard with other batch. Mr. 45, 45.1, 45.2 are linked matters. You are seeking adjournment in one of the linked matters, saying that I am only seeking in that. What happens to other two cases? They are automatically adjourned. He is opposing the prayer. What can we do? We will take a call after the break. Let him oppose. We will. What are the reason record for seeking adjournment? We will take. We will have to pass a judicial order, right? Because he is opposing the prayer. If he would have agreed, we would have adjourned. He is opposing. We will have to take a call. We will have to pass an order. You make a submission. He will oppose it. We will record it. Or whatever order has to be passed, we will pass it.
Break ആയില്ല. ഇവർ ലഞ്ച് കഴിഞ്ഞത് പോകും.
Hello, court officer. Hello, court officer. Hello. Court officer.
55. Sandeep Kumar Patil. 50. Ready? Huh? What handicap? Yes, Mr. Patil, some other date, tell us.
One
That's what-
date, one date
some
ಹೇಳಿ ಅವ್ರು
date,
oppose ಮಾಡ್ತಾರೆ.
You tell us what date. He will agree. What date? Yes, Mr. Hey, what is another matter? Has to be argued, right? Is what? 6. Then he is saying after 1 week. Oh, what date, Mr. Patil? 14. Then it counsel for respondent. 14. Right. Yes, Mr. Patil. All right, 50. Learned counsel for respondent. Mr. Chandrakant R. Gole. Learned counsel for respondent prays for a short accommodation to enable him to prepare the case and argue the same. Aforesaid prayer has not been graciously opposed by learned counsel for the petitioner. Placed on 15th March 20.
46. It's Pradeep.
My lord, happy for the respond in this case.
Yes. Who appears for respondent?
I appear for the respond, my lord.
Where is he? Ask or let him.
My lord, I am appear for the respondent in this case.
Huh?
I am appear for the respondent.
We'll see in part. Nobody is appearing. We'll see
Please.
what is to be done.
Please, my lord, please.
Yes. We knew what. Yeah, after. Then wait. Thursday. It's 47, right? 47. Learned mark the presence. Learned senior counsel for respondent. Learned counsel for the appellant prays for adjournment. Based on 9th March 20. But 48, seen in this party.
Appearing for the appellant's counsel in this matter, my lords. Appearing for the appellant's counsel in this matter, my lord. Serial number 48, appearing for the appellant's counsel, my lords.
You appear for
The appellant's counsel is serial number
respondent
48.
number 3. Learned counsel for respondent number 3 to 6. Prays for adjournment. Enable her to prepare the case and argue the same. List after 1 week.
The CN Srinivasarao, MS Venugopal, the G. Karpus Shastri, Commit Advocate, Pathor, number 52, the Arvind B. Chavan, the Rashid K. The Rudraka Shankar.
Respondents are not there. We pass it over.
Number 53. DB Patil, Government Advocate, RB Sadashivappa, Prasad, VV Gunjan, 54, Sri G. Lakshmishwar, Gundrajayan, MP Gita Devi, Fifty-five, Sri Devi Narasimhan, Sri Girish Chandrayan, Jira Maria,
Huh? Why? In all cases where Mr. Reddy is appearing, people are seeking adjournment. Huh? Or the presence learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same. This next.
56, Sri MP Karati, Government Advocate, 57,
Huh?
Ashok, 58, Sri Rajendra S, Government Advocate, Mahaleshwar DC, Ashok,
Hello,
59, Sri Somsekhar KM,
9th March. It is 9th March. No? Yeah, day after, after 2 days. Thursday. Yeah, Thursday.
51, Sri Somsekhar,
Appear for the appellant. Appear for the appellant, Miller.
Why?
Yeah, just to see evening.
There is no accommodation here in the High Court.
No, Sadashiva is there.
Huh? Appearance of one counsel before another court is not a ground for adjournment. Correct? You don't seem to understand. What did we tell you? What did we tell you? Ashok.
He is there. He is there. Because computer only judges were available. I was not able to see that. No. And my still no, see, it is not submitted.
For the respondent, Miller.
This problem.
But I appear for the respondent.
For the, they are calling.
55, Srimati HR Renka, Srimati HR Renka, also 56, Sri DC Deepak, Shekhar Shetty, also 67, Government Advocate, Vivek Kollam.
Hello.
You are ready, no?
Ilvan Allah, I will not see because I cannot see because I cannot appear. No, it is the respondent. If I put on the this one, I can see it. But I am not able to see it. I am seeing only judges. Other side, I cannot put my name. They are calling. No, I will be appearing this one in computer then because my name is not there. Name was there and not there. That's it. So problem, yeah, it is. I don't know. ಕಾಣಿಸ್ತಾ ಇಲ್ವಾ ಅಂದಲ್ಲ ಅದು you just understand what I am telling.
Which item 70? Yes, madam. 70. Take us. We now go child custody. Pass over.
Passport matters, number 36.
No, first round, what did we were asking? To settle the matter, right? 2.5 lakhs, yes.
5 lakhs over.
Ah. The counsel for responded to them.
Said that he is also coming.
The respondent has come. Display board, right?
In our
He said no, the client respondent has come and told him. Mr. Shivramu had also appeared in first round. Though the counsel for parties were present when the case was called in first round, yet when the case is called in second round, none of them is present. Awaiting their appearance, hearing deferred, list next week.
37, network.
First round also normal. Huh?
Right.
Yes. Why it was passed? No counsel for appellant had appeared in the first round, yet when the matter is called in second round, he is not present. None for respondent, even when matter is called in second round. Awaiting appearance, hearing deferred, list next week.
38.
I appear for the appellant, your lordship. I appear for the appellant. I beg
What
you.
happened?
I apologize for the
First round
first
you were
time. I
there.
could not hear properly. I will make my submissions, your
Go there.
lordship.
Up there. None for the appellant.
Appear for the
Matter is
appellant,
called
your
in
lordship.
second round. What's your name? The counsel for respondent.
I appear for the appellant, your
Appears
lordship.
not interested. What happened?
39.
Hey, no advice. Okay. That's the difficulty. If we say something, you straight away pass on like this court directed, this court advice. Why will we are not parties? We are not parties to the list, right? Supposing if this appeal is allowed or dismissed, are we going to get any benefit? Then how can you say that as per the advice given? We don't give advice. Or is it? What is the advisory jurisdiction of the court? That to Supreme Court on constitutional questions. We don't advise anybody. Much less in a private dispute between husband and wife. Why would we advise? So it's better that we write a judgment if you take it like that. Efforts to this is all being done under section 89 of the CPC. If you don't understand, you say that the court is advising us, then you will take a ground there also that the Supreme Court, that the court had advised us, High Court advised. Doesn't augur well. Argue. Huh? You said, madam, 10 to 15 lakhs. You said, madam, 10 to 15 lakhs. He has come up with a reasonable figure. We can't, force him, any of the parties, for you to not to accept, keep on litigating, file execution. What is it? No question of leaving, madam. You have to agree. Please understand, you have to take a call. There's no question. Did you not say, madam, 10 to 15 lakhs? Did you not say? Tell us. And we put it to the council that her offer is between 10 to 15 lakhs. He has agreed for 12 lakhs. Fair enough. You said 10 to 15 lakhs. You should have at that time said that I want 1 crore. Then we would have decided the appeal on merits. So marriage expenses, 25 lakhs easily. Marriage expenses.
Hello.
Will it not be as per status of your husband? You should have the sources to pay. If his appeal is dismissed, how does it matter? Keep on filing execution and recover the amount.
Virtual hearing. Please.
No, he says overall. If you don't agree, we are not forcing you, man. We are no way. Don't feel. Fine. All right. Wait. Yes. Stick only. Okay, stick.
Hello.
Where is my
Yes. Okay, I'll call you because I'm in a virtual hearing court. Okay.
ನಾನು ಮಾಡ್ಕೊಳ್ಳಿ ನಾನೇ ಹಾಕ್ಕೊಂಡು
ಬೇಕಿತ್ತಾ?
ಆಫ್ ಮಾಡ್ಬಿಟ್ರಾ?
ಅಯ್ಯೋ ಚೇಂಜ್ ಆಗುತ್ತಾ?
ಬರುತ್ತೆ.
ಅದೇ ಬರುತ್ತಲ್ವ? ಅದು ಮತ್ತೆ ಪ್ರೆಸ್ ಮಾಡಿದೆ ನಾನು ಅಷ್ಟೇ.
Yeah, dude, I know. That thing keep on in there, thunder on the horizon. I don't know how long it's gonna last.
Thanks, be careful.
I mean, look, we got the outside cover, we're trying to keep that, but now when we need it.
Procedure. What is the allegation?
ನಾನು ಕರ್ಕೊಂಡ್ಬಿಡಿ ಆಮೇಲೆ ಕೂತ್ಕೊಳ್ತೀನಿ.
Thereafter, he has registered, which is not really for FIR, but it is registered.
Like which paragraph you said? Paragraph?
Paragraph 6. 5/8/2004. See it.
Assault.
Assault. He had taken treatment from top para 6.
Medical prescriptions.
Plenty has produced.
But no
Some prescription fee he refers to chest pain. This is something. What he earlier once he has filed a petition, it's a withdrawal. That nothing.
what could profit?
Yes.
Yes. Only on the ground of cruelty, right? You filed a petition on the ground of cruelty. What is the government's with regard to cruelty? Show us from the petition.
Right, we used to avert Character of the father.
Is going to be everything. Good point. Good point. Isn't it real?
When did you fight?
Three, 1-3. 1-3.
They have decided. Right? Patients in the evidence substantiated. Yes.
16-7 2005.
16/7/2005.
Section 9.
What have you said? I mean, you have conveniently transgressed to her pleadings. What have you said in your petition, cruelty? That she assaulted you on a particular date. And what else?
And you'll take me all you want.
Demand for a separate house, rightly or wrongly, this court has held it does not amount to cruelty. So what is it? Tell us what is the averment in your petition? What is cruelty?
Charity to pay.
Which paragraph? What is the evidence of having spent the amount? Statement. This all. Which paragraph is the averment? Forced to raise construction, therefore it is cruelty. Which paragraph? Please read. Yes. So compelled petitioner to construct 9 houses, therefore cruelty. Read further.
Site belonging to the 7 and the 7 the responding has because all the houses getting a rent of
Pleading that cruelty. This amounts to compelling you to raise construction of 9 houses amounts to cruelty. We are asking you, what is the allegation of cruelty in the petition? Please read.
That's all.
respondent on several occasions written the petition that bank or properly debated and listen whatever the respondent says. The respondent here and had issued all the parents. The mother of the petition visited petition of the parent. The respondent accused the old lady and sent her away from the matrimony. The mother of the petitioner was on even to see her grandchildren and the petitioner. Personally has responded to very clear and simple for petitioner.
I am
Respondent
allegations.
Petitioner and more taking all the wrong things into the respondent interference by her taking this petition are all please and more objective. 8/2004
That's the only thing. That's the only pleading that she has assaulted you. What else? Hey, Mr. You understand? What is the other incident? Only one thing you have said that he assaulted you. Therefore, cruelty. What else? What else? Point out from the petition, Mr. That's all. Assaulted you on that. Yes, fine. That's it. It cannot depend on 42 circumstances of her. The whatever the council has advised, she has drafted, or I mean, it has been drafted, whatever. Each litigant reads it, Mr. We are asking you, you have only said that on 12/8/2004,
Right.
you were assaulted for which you took the medical treatment. You have not produced any certificate showing that you received medical treatment, whatever medicine was prescribed, nothing. Now give it. What case law?
5/8. It's 5/8.
Wait.
No, 5/8.
Oh, 5/8. What is it? Right
of principal enunciated hearing will be made now examining whether the allegation made by the wife by her counsel to the petitioner is brought amount to interfere with sets of clause. Related law is the portion of the written statement have completely set out by years before. We have also set out in the said paragraph. Declaratory statement made by the respondent counsel in court in justification by the petitioner in his profit analysis. Prove that we said the argument be read in the they were made at the same time. It must be remembered that the fight was merely depending on what totally unfounded allegations on her character. Necessary for her to go beyond that and lead the petitioner to the mental patient. The fight is not a normal person that we require psychological treatment to restore his mental health. That we suffering from paranoid disorder and mental he and all the members of his family are a bunch of parties. It is not as if these words were uttered in a fit of anger or another emotional stress. They were made in part in fight in the court itself. That effect was put by counsel instruction in the cross examination. Even in our additional written statement, she has asserted her right to make a fact of facts to defend herself against the fact that imaginary and these are not clear by they are positive evidence of mental illness. A state of insanity in the mental state of the event is an advocate practicing this court as well as in the area. The High Court is tried in Delhi High Court, making such a witness was found to cause the intense mental pain and
Hey, Mr. That is in the facts of the case, right? In the peculiar facts of the case. That was granted in peculiar facts. Where is the proposition unfounded? You have not stated anything except saying that once you are hit and now you are relying on her written statement. Oh.
allegation and counter allegation. There is all there is also not possible to again go back and try it, but believe it is intention as you work. Material you are working in the pendency of the petition justified by the respondent you are working is already an amount of mental clarity. You also case of distance there is disturbance to the family which is not having a
Appellant was cross-examined. Yes. See, this is 142, Article 140. We don't have that power. You will have to travel northwards in case it is decided, right? No, we can't grant 10 years separately, therefore, can't do it. Supreme Court has said that it is our power only, High Court cannot do it. You know it. Yes. That's it. Yes. An execution proceeding for recovery of arrears of maintenance. Is whether a ground under section 13 is made out. Well, what is the, have you laid any evidence to prove the averments made in para 8 of the petition statement of objection? Are there? Despite that, you had the guts to turn down the offer made by the appellant. You have not entered the witness box. Despite that, you had guts to turn down the offer made by the appellant. All right. What can be done? Yes, go ahead. So what is the evidence? Why have you made like this? Para 8 of statement of objection, you have made an averment. What is the evidence list? No evidence. Why should not be granted? Making unfounded allegation in the pleading amounts to cruelty. This is a severe thing, right? You are not, so far as husband is all right, you are not even sparing your father-in-law. Huh? Saying anything about your father-in-law, not entering the witness box, what is this? He may be a bad person, characterless, whatever. You should have this thing, which girls he brought home. You should have sent summons. Who came? What you yourself, you have not appeared. Huh? Unfortunately. The thing is unfortunate. I got it.
Make sure that they felt received a video. But we wanted to make sure that you were able to experience this as well. So
Unfounded allegation in the pleading amounts to cruelty.
appraisal out there,
That's unfounded allegation in the pleading. All right, anything else, madam?
Because you've
Yes.
given so much to your community,
Yes,
to
appeal.
your family, planet.
Under section 19 within bracket 1.
This is that moment where you
Unfounded allegation in the pleading.
Yes,
Where is it?
we wouldn't be in this situation.
You will get this application, this appeal under section 19 of the Family Courts Act 1984 has been filed against judgment and decree dated 16th of July 2015. Passed by the Family Court, by which petition filed by the appellant seeking dissolution of marriage on the ground of cruelty has been dismissed. Paragraph facts giving rise to filing of this appeal briefly stated are that the marriage between the parties was performed on 5/3/1995 in Bangalore. Full stop. After the marriage, the respondent joined the matrimonial home and parties lived together for a period of 1 year at Devara B. Sanadahli. DEVARA PISANAHALLI. And later on lived at Agara AGARA in a rented accommodation. Full stop. Is not in dispute that a daughter and son was born to the parties, and presently the son is aged about 21 years, whereas the daughter is aged about 22 years. The appellant filed a petition paragraph. No? The appellant filed a petition.
16/7/2005.
The appellant filed a petition on or about 21st March 2011, seeking dissolution of marriage on the ground of cruelty. In the petition, it was pleaded that on 5th of August 2004, it was pleaded that on 5th of August 2004, when the appellant was taking a bath, the respondent started quarreling with him and begged the petitioner with inverted commas, let LATTANIGE.
Where parents with five, children, 17.
In bracket 6. On the left arm, it was pleaded that the appellant, it was further pleaded that the appellant on account of appellant sustained internal injuries and received treatment from the doctor. It was also pleaded that that the respondent used to ill-treat the appellant and as well as her parents who were suffering from paralysis. Ill-treat so and so parents. It was also averred that mother of the petitioner. It was averred that also that mother of the appellant was suffering from paralysis. The appellant sent a legal notice on 12/8/2004 asking the respondent to join the matrimonial bond. However, the respondent neither replied to the notice nor joined the matrimonial paragraph. The appellant thereupon filed a petition under Section 9 of the Hindu Marriage Act seeking restitution of conjugal rights on or about 16/7/2005. However, 16/7/2005. However, withdrawn. When was it withdrawn? However, subsequently, the same was withdrawn on.
Family were good in this area. And suffered.
However, the same was subsequently withdrawn. That's it. Withdrawn. Accordingly, the appellant sought resolution of marriage on the ground of cruelty. The respondent entered appearance and filed a statement of objection in which inter alia the factum of marriage as well as the birth of two children of the wedlock was admitted. It was pleaded that of the respondent had purchased a site in her name and her father along with her brothers constructed 9 houses without financial assistance of the appellant. It was also averred that father and brother have availed of the loan for construction purposes. It was right to open.
Walk through the entire house. So first thing,
the road is always kept open wide.
placing it with the new look. Number 2, we are going to build
because stated that in para 8 of the statement of objections, it was stated that the appellant was addicted to several bad habits, and when she questioned the appellant, she was irritated and was abused. It was denied that in the statement of objection, it was also denied that the respondent assaulted the appellant on 5/8/2004. That family court on the basis of family court, no, paragraph. The appellant, in order to prove his case, appellant in order to prove his case examined himself and produced documents in the exhibit P1 to P11. The respondent entered the witness box and did not enter the witness, either entered the witness box nor produced any documents in support of her claim. The family court by judgment dated 16th of July 2015 dismissed the petition filed by the appellant. Learned counsel for the appellant. Learned counsel for the appellant while inviting the attention of governments made in the petition.
You're creating a pre-built, three-person bed that has block style to it. We're also creating a petition and this and Trinity, oldest, Zion, youngest. We're not just sharing. I remember taking the thing and
governments made in the petition as well as the evidence of PW1 submitted that from the evidence of the appellant, it is evident that respondent subjected her to cruelty. It is also submitted that that a reckless and wholly baseless allegation was made in para 8 of the statement of objection, not only against the appellant but his father as well. The court of opposite submission. It is submitted that opposite action of respondent in making a baseless allegation in the pleading amounts for cruelty in support of opposite submission. Reliance has been placed on decision of Supreme Court in so and so. D. Bhagat versus Mrs. D. Bhagat. KIR 1994 Supreme Court 71. As well as decision of Supreme Court in
But I need to sit down and do some things.
Srinivas Rai versus DA Deepa. 2013 5 SCC. Learned counsel correspondent has supported the judgment and decree passed by the family court. We have considered the submissions on both sides and also. It is right law that standard of proof matrimonial dispute relating to cruelty cannot be said to be as applicable in case of a trial under the Code of Civil Procedure. However, the parties are required to describe the measure and standard of cruelty and to lead cogent evidence in support of plea of resolution of marriage on the ground of cruelty. See Maya Devi versus Jagdish Prasad, KIR 2007 Supreme Court 1426. Full stop. It is equally well settled. Para 10 in celebrated case of Astani versus Para 11 Samar Ghosh versus Jaya Ghosh. Don't delete Samar Ghosh. There is specific instances, so don't, instead of Samar Ghosh, specific instances of cruelty. Para 9.
This is major. We can't have this Kumar
and this. Neelam Kumar have to be pleaded. Huh? Filed and vigorous allegations. That paragraph. The backdrop of opposite paragraph. The backdrop of opposite well settled legal. We may advertise the facts of the case in admittedly, the marriage between the parties has been performed on 5/3/1995. It is also not in dispute that the appellant is that from the wedlock 2 children have been born to the parties. Full stop. The appellant in support in order to prove his plea of dissolution of marriage is required to state the specific instances of cruelty with precision in the pleading, and mere ordinary wear and tear of the married life does not amount to cruelty. Full stop. In the petition under section 30, in the 30, the petitioner has the appellant in para 9 has only pleaded that para 7 has pleaded that the appellant was assaulted on 5/8/2004. Apart from leading in the opposite paragraph, petition with regard to the cruelty. The appellant in his evidence has stated that he had sustained internal injuries account of the opposite the incident on account of the assault which took place on 5/8/2004 and was treated. However, no medical records produced to the contention. The allegations about the cruelty, the evidence made with regard to cruelty are vague and baseless without any factual foundation. The family court, mere allegation of the petitioner. The family court therefore has rightly found that the allegations of cruelty are not made out. So far as reliance placed by the appellant on the decision of Bhagat versus so-and-so Bhagat Supra, V Bhagat Supra, V means victory. Bhagat Supra is concerned, suffice it to say that in the aforesaid decision, in the facts of the case, the Supreme Court had found that Honorable Supreme Court had found that the ground of cruelty was made out on account of unfounded allegations made in the pleadings. Full stop. The appellant has to succeed on the strength of his own case and cannot rely on the weakness of the case of the respondent. Though we are aware that respondent has failed to enter the witness box. However, the fact remains that the appellant has been cross-examined by the respondent and the entire case and the averments made in the petition as well as and from his evidence and from the averments made in the petition as well as his evidence. Evidence, it cannot be held that respondent has treated the appellant with cruelty.
To be a teacher and to be a
paragraph in view of aforementioned reasons, we affirm the judgment and decree passed by the family court in the result. Appeal fails and is hereby dismissed. One very good. You filed a memo for this thing. He was also not there.
And it is
We decided to put these dividers up because.
How much? 5 lakhs.
Huh?
I get a lot. I can actually store stuff. You can do that? Well.
Give a memo, Mr. Right, just now. You speak to him, right? Joint memo you file, no? Ah.
But we
Hey, give a joint memo, Mr. What I mean, like you wanted to. Thereafter, you will say that court is advising. Huh? We are not advising. Right? Give a memo, right? So that you are bound by that. Whatever. Give Mr. Talk to him, Mr. And give a memo. We will take it up. Give a memo. Whatever time you tell him, how much time and this thing, both of you sign. Please give. See, we were insisting at that case. Previous case. You know, you know what happened in previous. Counsel for wife said that I want 10 to 15 lakhs. We told the appellant that please pay. He agreed for 12. She denied. Now the decree has been affirmed. She is into litigation for his remaining part of her life. We told it doesn't matter, right? Doesn't matter what. So therefore, please file a memo. We will take it up. Now, Mr. Otherwise, it's other. If you don't file a memo, it will be adjourned. Whatever order we have passed.
Please, my lord, I represent the appellant in this matter, my lord. My lord, they are living separately for the last more than 10 years, my lord.
None appears.
I represent the appellant, my lord, in this matter.
Benjamin. Go to the hearing. Is there appellant?
I represent the appellant in this matter, my lord. Right. Right. There is a proposal of the settlement of the things because the reason that, my lord, they are living separately for the last 15 years, my lord. Therefore, my lord, they are negotiating for the settlement for once per trial. They want to settle issues. But they want to settle the issue, my lord. Therefore, my lord, kindly accommodate 1 week time so that report the settlement. Otherwise, we'll proceed with the matter, my lord.
Talks are going on there.
But I think hearing, Lordship is hearing, my lord.
Settlement talks go on when the case is listed, the number is called. Twice.
Please, my lord, I'm hearing, my lord. My lord, their proposal for a settlement, my lord, kindly accommodate 1 week. Sorry, my lord. But kindly accommodate 1 week's time, my lord, so that there is a settlement possibilities are there, my lord.
My lord, I am paying for the respondent in this case.
Present.
My lord, I am not able to hear the proceeding, my lord.
For the appellant appeared in the first round, however, none for respondent.
My lord, I am present for the, I am for the respondent in this case.
Case is called in second round, none is present.
My lord, I am appealing for the
None
respondent.
has appeared on behalf of the appellant. awaiting appearance of learned counsel for the appellant hearing is deferred just after 1 week.
Appearing
Nobody had
of
appeared,
the
right?
appellant, my lord. Appearing for the appellant, my lord, in this matter.
None for the appellant even when the matter is called in second round.
My lord seeks for a week's document.
Learned counsel correspondent it appears that the appellant was not interested in.
No internet access.
Same is therefore dismissed for want of prosecution.
My lord, may I submit, my lord, I'm appearing on behalf of the appellant counsel. My lord, in serial number 48, my lord.
Some problem, right?
Serial number 48, my lord, appearing for the appellant.
Called
My lord,
Internet.
my lord, serial number 48, my lord, may I seek for tomorrow, my lord, in this matter.
ಇಲ್ಲಿ ನಮ್ಗೆ ಇದೇ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ ಅದೇನು ಬರ್ಬೇಕು ಸ್ಕ್ವೇರ್ ಅಂತ ಸ್ಕ್ವೇರ್ ಇಲ್ಲ ಅಂದ್ರಿಯ ಅಂದ್ರಿಯ
1 minute.
ಹೌದು
49.
Serial number 48, my lord, appearing on for the appellant, my lord.
There.
Tucker.
The 49. Promote. Respondent counsel. Yes, Mr. What to do? Not present. He will file an application seeking recall on the ground that order has been passed in violation of principles of natural justice. We'll adjourn it once with say that it will be Mr. Chandranath Tariga, learned counsel for the appellant, none for respondents even when matter is called in second round. Awaiting appearance of learned counsel for respondent hearing is deferred. It is made clear that in case no appearance is made on the next date of hearing, appropriate order shall be passed. What? Yes. All right. So list after 2 weeks. One. What happened? Nobody is speaking anything, right? All right. So, Mr. What do you want? Yes. Somebody had appeared. Mr. Natraj.
On both sides, except government.
No, he is appearing correspondent. Not for the appellant, even when the matter is called in second round. Mr. Krishna Shastri, counsel, on number 3. Yes, order not interested in prosecuting the appeal. The same is therefore dismissed for want of prosecution. The Arvind V. Chavan, the assistant, What happened? Your opponents are not appearing. Huh? So next week or whatever. Next week. Mark his presence, learned counsel for the appellant, none for respondents, even when matter is called in second round, awaiting appearance of learned counsel for appellant. Respondent hearing is made clear. In case no appearance is made on the next date of hearing, appropriate order shall be passed. List in the next week.
पार्टी आपके सदस्य के ऊपर किसी प्रकार गुंजा
Side is not there. Unless you want to say that you have nothing to argue. Yes. So then we will have to await his appearance. You know what order will be filed, what review petition will be filed on what ground? Which ground? Order has been passed by the division bench, violation of principles of natural justice. The council was unwell and the court ought to have adjourned the matter. Right? We have learned that being an advocate is a fun, really. Enjoy. We keep on advising this, Mr. Additional government advocate, not to accept the offer. Correct, no? And he is convinced also. Mr. P.B. particular, Mr. Government Advocate for additional government advocate for respondent number 2. Not for remaining respondents, even when matter is called in second. Awaiting appearance of remaining respondents, hearing is there. It is made clear in case no appearance is made on the next date of hearing, appropriate order shall be passed. List well. 3. Achha, respond number 3. Not contesting respondent. That's right. None for remaining respondent. Where do you want? Next week? List next week.
For the respondent number 2 in this matter, my lord.
Sort a password.
My lord, I am the advocate for
What a
respondent
password
number
in this
2 in
case.
serial number 54.
That's correct, Mr. No, what I mean. Engaged Mr. Patil, therefore he has immunity from appearance. What is this? The submission. First round also you told Jai Kumar Patil, therefore it be passed over. Second round also, what does it mean? Translated into simple words, what does it mean? That he has immunity from appearance, he will appear as and when convenient and the court should wait. This is what you want to say. No, what does it mean? How are we concerned who is appearing? First round also you said the same thing. He is on his legs. On this very ground, you told us, how do we know that his name doesn't appear? How do we know he appears? Because you told us that he is appearing, he is busy, therefore pass over. Again, you are saying, it gives a very wrong impression, Mr. to all those persons who are sitting. Don't think that you are above law because you are a BDA, not Bangalore Development Authority, right? So therefore, above process of law, above everything. Not fair sort of an attitude. You are meant to serve people, right? What can we see our predicament? What can we do? Passover is sought on the ground, council is B. Adjournment is sought on the ground, council. They don't have any regards for this. Why he should not be here? No, we are also sitting here. We are also all the time sitting here. If you are on your legs, we are sitting here. Yes, Mr. What, Mr. Raghavan? What date? What date? Tell us what can be done. Mr. Rao, you better be busy, prepared on the next date of year. Don't depend. Yes, what date? According to, since it is being adjourned, you are ready. Therefore we are asking. Yes. Whatever you tell us the date of your convenience. Huh? 13. Praise for it. Mr. Bhagwan, Learned Singh Council for this fund number 4. Counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same. By way of indulgence, hearing is deferred. This on 13th of March 23.
For 56.
It's Friday.
Yes, sir.
First day of the week.
What is it? He will be interested in admission.
Huh?
Admission matters, sir. It's again
Admission?
various, sir.
Yes. Who appears for respondents? No. Also, this can be heard, right? Unrepresented. It can be heard, right?
Appeared.
Huh?
Appeared.
Lot has appeared in this. Are the presence. Let this appeal be listed before a bench in which one of us, not honorable, etc. Madam, because we ourselves signed the order sheet. It is not honorable, my lord, etc. Not his name only. Vijay Kumar Patil J is not a member. That's all. Not lordship, honorable, this thing. Because we signed the order sheet. Cannot call ourselves honorable. Yes. But What clean?
Is equivalent to 10 division. Yes. Later on, 2059 the board blocks the federal has approved blocks the recommendation for observed of the point of along with several different capacity and different care. From 1910-2006 blocks, official communication was made to the that he has been observed. Take note and bring these dates because there is a issue.
What 1910-2006?
That is the official communication made, stating that not been observed in the credit. Yeah, not the first respondent. That makes several representations that it shall be considered as against first division assistant. Both. On the ground was that one Mr. Rajan has been considered as against assistant account post is equivalent to a. But sir, under the regulation of the cadet, FDA qualification then only works. That's not the SDA is concerned about the graduation 10th and above as the but there are the present education is quite because consideration of the prayer clause was only to consider the representation and to pass voting. But even supplement one two. Where not the other single but instead of acting as not consider the consider the case of and not hold that. The graduation in the year 2008. From that day, it is entailed for, though not for the activity for all the practical, it has to be considered from the but accurately on 23/9/2006, the board passed an order absorbing what the first assessment in the case of second division. So as what the first division assistance is concerned, one is that the candidate should be a graduate and not which activity was not sitting as on date of after the absorb the placed in the care of second division and
Hear you. Yes, yes, Mr. What do you say? The prayer was as pointed. No, we will hear, but provided what is your initial. Prayer, come to the prayer made in the writ petition. What was it? Therefore, the submission is, as pointed out by him, that the prayer was only for consideration of representation, but the learned single judge has even adjudicated the entitlement. That question has should have been left open to them. The prayer itself was to consider the claim. What is? All right, we will hear. Yes. He has to carry on. Fine, fine. Yes, yes, all right. We will hear you further. Yes. What, yes.
Considering what the degree acquired, not admittedly as not 310 notes 2006 is the last after completing the course.
What 310 2006 is what? BSc degree.
But that is BSc.
BSc.
Yes.
Ah.
That is on notes 3rd of October 6.
Yes.
The absorption notes is prior to that. It is 23/9/2006. The accepted notes the absorption in the care of second division assistant without any level.
Yes.
Annexure C notes, page number 57. But first thing notes which is part of the that he has completed the graduate by way of representation dated 27/5/2008. Where she clearly notes says that I so and so working for the CGM section as project assistant 6 July 2005 and got confirmed on 3rd October 2006 based on my PUC qualification and working still on probation. This is the admission process.
Which?
That is the
Yes.
Second paragraph notes says, now I would like to bring to your friend that I have completed BSc degree. This is year 2008.
Yes.
Lastly, towards she request to consider the case as considered in the case of Rajanna's case, and please do the needful. Come with me in the next position is vacant as CDM assistant equal repair. Whereas Rajanna is he belongs to a different cadre, that is accounts cadre. And no one else has been promoted or else to the next cadre. Here it was not he acquired the graduation or needed. And once the respondent number 1 here in what's is to in the case of second division. Because there is no question of based on the statement the certificate changing notes there because they will have notes for the norms described under the regulations C&R regulation. For the C&R regulation the page number 98. What's the page number 19? Start.
19.
On the additional.
Oh.
Get
Additional documents, Mr. Nagrat. 51. Continuous numbering. So it's 346 or something. Additional documents IA is dated 22nd February 20. Huh? Acha, this one. 19. Page 1.
Page 131.
Rules. Yes.
Okay.
Page. What?
Since 2 years, that has been reduced to 1 year. So we have been. And in the company, as on the date of either on the patient or on the. However, all such employees were not satisfied of the student or not satisfied or were not given consent for can be observed in the ultimately notes who can be observed notes is stated that anyone who complains with one of the eligibility taking the articles can only be but now kindly come to note page 51. Page 50, 52. Number 11. Page number 22.
Which this IA?
Page 52.
Of this IA?
Yes.
153.
The last but one column. We have direct recruitment. Yet, graduate in any discipline, with 3 years experience in handling development, this is the qualification. Administrative note, he doesn't protest.
It's not there. He's reading. Not where it is not there. Something different page numbers are there.
This is the tabular statement.
Tabular statement 1, statement 2.
The statement notes 7. Statement 7. That is the page number 15.
First division assessment.
The qualification and on the table, what was in existence was the art for the graduating many The qualification, right? And attending note, you are not getting as on date of eligibility. Now, the previous page note is the serial number 6. So that the accounts officer post is concerned, to which not one Rajana was considered. The eligibility criteria prepared not in the serial number 6. There it says that calculating any from a recognized unit with a minimum bar rate in AADW, ADA, MCOM to possess at least 5 years experience in accounting in commercial organization of accounting, banking, or preparation. This particular category note that is qualification note, he possessed, whereas Rajana is, that is a different career altogether. And he has not been considered notes as against the FDA. Initially, notes whatever done completely. Then this accounts officer post note was downgraded and was accommodated as accounts assistant accounts. Later on, on querying MCOM, he was accommodated for the different career, that is accounts officer. My notes is that the respondent number 1 here cannot be equated to or considered to be on par with. And as per the CER list, that is based on record, that is the page 133. The document is connection R70. Page 141.
245.
Translated. This translation 245.
We'll continue tomorrow. Yes. List for further hearing. Like learned senior counsel for the appellant commences submissions, however, on account of paucity of time, the same could not be concluded. List tomorrow for further hearing.
My lords, kindly, my lord. My lords, kindly. My lords, kindly. Serial number 6, my lord. Serial number 6, I was appear in first hearing, my lord, on online, my lord. My voice not recognized. It was dismissed for default, my lord. Serial number 6, my lord.
If the order sheet has been signed, please file an application for restoration. It has been signed, Mr. Please file, we will restore it.
Same also happened, my lord. Last occasion also same also happened.
Sir, settled.
Settled. Oh, good. See, Mr. Shiv Ramu, we told you, right? Item 36. This MFA has been filed. This appeal under petition. This appeal under section 28 of the Marriage Act has been filed against judgment and decree dated 27th October 2014, passed in 31 of 1998, by which petition filed by the respondent under section 13 of the Act seeking dissolution of marriage has been allowed. Paragraph. Dependency of the appeal, learned counsel for the parties jointly submitted that the dispute between the parties have been amicably resolved. Full stop. They have invited the attention of this court to the joint memo filed on behalf of the parties. Paragraph. Joint memo for the parties. Paragraph. The respondent has agreed to pay an amount of ₹1 lakh every 5 months for 2 years in total, a sum of ₹5 lakhs to the appellant, subject to which they have agreed to dissolve the marriage. Paragraph. In view of aforesaid compromise arrived at between the parties, the marriage between the parties performed on 12/3/1995 is dissolved by a decree of divorce. Full stop. Number 2. The respondent shall pay a sum of ₹5 lakhs every 5 months for a period of 2 years to the appellant. Appellant in full stop. Thus, the respondent in all would pay a sum of ₹5 lakhs to the appellant. Every 5 months. Yes. Oh, what? Failing to do so will land him in jail. What? You have the remedy, right? Under you can always file an application for recall. Right? But what to do? Undertaking is there, and let's trust on what can we do at this point of time, right? So the appeal is disposed of in terms of the aforesaid compromise arrived at. Correct? They obviously, it goes without saying. If he doesn't do it, you are appearing, Mr.
He is undertook. He signed, that is sufficient. His party is there. Let him sign.
All right.
He used to pay money.